We'll look now at the case of Menorah Chapels at Milburn versus Needle. That's a New Jersey Superior Court Appellate Division case, and it follows a summary judgment motion. The question here that we're dealing with is really one of the divisibility of a contract. And if a contract is clearly, maybe not clearly, but clearly divisible, then the court can kind of cut it apart and give relief to one party and balance it with whatever it does with the other part of the contract. Let's take a look at this case now. In Menorah Chapels, the family of the deceased wanted to make sure that the Jewish funeral chapel provided a number of services, and they were to begin with, of course, the acceptance and embalming of the decedent and so forth. But under the Jewish faith, especially Orthodox, it was important that the tradition was kept of having folks look over or watch and wait and guard the body during the time between that embalming and the interment of the decedent. So the chapel agreed to do all the initial services, removal, embalming, etc., and providing the shrouds and the shmira. And you've just read about what that is. And they were also to provide the people to perform that. And those were the shimron. And there were supposed to be 6 shifts to properly conduct the shmira at a cost of $900. Well, what happened was that because of the Sabbath and the observance of the Sabbath by some of the people that should have been there for the shifts, the 6 shifts, there were only, in fact, 3 of those shifts, and that was a breach, let's say, of the requirements of the contract overall. At least that's what the family, the Needles, said. Let's see what the court did with that. The court had to deal with the question of whether, the First Amendment question of whether this should have been before a Jewish religious court, or if it was properly before a civil court. The court determined that because it had nothing to do with the traditions or the manner of performing the traditions or any of that, but only had to do with whether or not the people, the 3 people with the 3 shifts, were actually provided, which would have been a breach of the contract, perhaps, if they weren't. So the trial court found the contract underlying the dispute to have been divisible in nature, and he allowed the Menorah Chapels to recover for goods and services, and he subtracted the cost of the shimron The New Jersey Superior Court Appellate Department determined that the trial judge was just plain wrong. The trial judge failed to take into consideration what the intent of the parties, both parties, had been at the time of contracting. The court looks at a number of prior decisions to explain why it reaches the decision it does. And one, for example, is the Integrity Flooring Inc. case from 1943, cited in the opinion. And that holds that a contract is said to be divisible when performance is divided into two or more parts with a definite apportionment of the total consideration to each part. And very simply, that didn't happen here. That wasn't the case with this contract. Well, Menorah Chapel argued that its contract with Needle was severable because its services were independently priced. You know, line items listed on the bill. No, that's not the case, because that is required by statute or by regulations in New Jersey. It's not something that was a negotiated list of items between the parties enough to make it severable. No, it's required by statute, that's all. The mere fact, the court, citing Corbin on contracts, tells us, the mere fact that there is a contract rate of payment per unit of performance to be rendered by the plaintiff is not sufficient to make the contract divisible. The court also looks at Restatement Section 240. That provides for an analysis of a contract to determine whether it can be divided into corresponding pairs of part performance by one contracting party and payment by the other. Even when such apportionment is possible, this court says, the restatement requires that the court look to the party's intent to determine whether the value to the injured party of what he receives is equivalent to its stated price, or whether that value is materially diminished by the part performance which took place. This court found no evidentiary support that the contract was severable, and there was no evidence that the parties intended for it to be severable. So they remanded the case, so that a jury could make a determination. They said, for example, with regard to this question of fact, we leave to a jury to determine whether the full provision of Shimron constituted a material condition of the contract. If a jury finds that Menorah Chapel committed a material breach of its contract with Needle, the chapel may nonetheless be entitled to recovery of the value of its remaining services on the theory of quantum merit. In other words, for the services, the value of the services that it did provide. However, the court went on, its damages can't be measured solely by reference to the unit price of the goods as it appeared on that invoice or bill or statement. So the court went on to take a look at a different issue, but it's worth mentioning here, whether the emotional distress sued for in the countersuit by the family was recoverable under contract law. And this is very interesting. Generally, no, it's not. However, such damages may be awarded, this court says, where the very basis of the contract is to furnish services that are designed to bring comfort to a party or to alleviate his emotional distress. That's exactly what these services were for. To alleviate or somehow alleviate emotional distress or somehow bring comfort to the grieving family. So the court reversed the trial court's dismissal of the counterclaim as well and remanded the case to the trial court.